If the parties are ready, we'll start with a quick sound check. We'll start with Mr. Reesner.
Hello, can you hear me?
Yes, I can. Thank you, Counsel.
Thank you, and you may be seated, and then we will begin with Mr. Mallory. First a sound check, and then you can start.
Check, 1, 2.
Excellent. Thanks, Counsel.
Okay, Mr. Mallory, you may begin.
Thank you, Your Honor. May it please the court, counsel. Your Honor, for purposes of the argument, may I remove
Yes, you may.
my mask?
Thanks for asking.
Thank you, Your Honor. Your Honor, my name is Billy Mallory with the Brick Gentry Law Firm, and I have represented Liquor Bike LLC since its inception in 2003. Neither I nor my firm has ever represented Vivone LLC, Brenda Rowe, or JSV Community Properties, the owners of Vivone LLC, and we have not represented any of the 4 owners of JSV Community Properties, which include Dr. Eugene Cherney and his 3 children. Your Honor, judges, justices, in the lower court, Vivone LLC sought to disqualify our law firm, the Brick Gentry Law Firm, and myself from representing a long-time client in light of the fact that Dr. Cherney is a member of an entity, Heartland Plastic Surgery, but he also owns an interest in an entity, which owns an interest in an entity, which owns the property that's neighboring my client's property. And this is a boundary dispute. This has nothing to do with medical practice. This has nothing to do with surgeries. This is a boundary dispute between 2 property owners. Now, the district court ruled that we were disqualified because of Dr. Cherney's affiliation with Heartland. Now, we find that lower court decision was in error and violates the standards applicable. The first thing that we must do is determine who is the client. Now, the lower court, in their analysis, went to the identifying conflicts of interest provision of the law and was really concentrating on comment 6 when we're talking about loyalty to current clients. However, in that court's analysis, they wholly disregarded who the client was. And if we look at the decision that was rendered, in fact, as we learned, as this court directed in the Bottoms case, we start with the rules. We need to look at the rules to determine. The rules govern how we practice. The rules govern how we do it.
So counsel, when should we consider a closely held company to be an individual person as opposed to a separate entity?
Well, thank you, Justice. Iowa courts have long recognized, and this court and the Iowa Court of Appeals have long recognized that corporations are separate and distinct from the owners. They are not one and the same. In order to have the identity of the individual and the corporation, you look to whether or not it is a sham entity. Was it undercapitalized? These are the arguments, and I know is sometimes disfavored with the assertion of the piercing of the corporate veil, but those are the arguments of saying we're going to disregard the corporate entity and then make the analogy of identity between the individual and the corporation. However, this court has never said that we lightly disregard a corporate entity, and when it has said that a corporation, even if it owns all of the stock in another corporation, that does not establish legal identity. This court has stated that ownership of capital stock in one corporation does not by itself create identity of the corporate interest. This court has held that the assets...
Counsel, that might not in and of itself establish that, but what, to Justice McDermott's question, is there ever a time other than a sham corporation where we would consider two entities to be the same client under this rule? Or do we need to go as far as what you're saying, that it's only in the sham corporation where we can pierce the corporate veil?
We do have the direction on that, Your Honor. If we look at Rule 32.1.13, organizational clients, and this is where what we had argued to the lower court was that in order to treat a corporation and another individual or entity as the same, the lawyer, a determination needs to be made that the circumstances are such that the affiliate entity is also a client of the firm. So in order to determine whether or not there is the identity between this other entity, what we'll call the affiliate entity, because that is what is stated in the rules. If there's identity between the affiliate entity and the client that in issue, then there could be an issue. Now,
So in other words, counsel, if 100% of the ownership rested with the doctor, that might change things? Is that what you're saying?
ownership, Your Honor, is not the end of the analysis. And the reason is that corporate entities are separate and distinct. And so when we look at ownership, you still would then have to go beyond that to determine whether or not other factors come into play. And I believe it was the SCI case that I had cited in our briefing, where the SCI, the GSI case that was cited, after quoting the ABA Commission's rules on professional ethics, where they talk about the entity theory. And we look at, when we have two entities, we look at the degree of operational commonality.
Well, right, like, so a wholly owned subsidiary might have separate boards and separate structures.
Correct. And so we look at operational commonality. We look at, to the extent that these entities are financially dependent on each other, we look at...
Counsel, but back to Justice Apple's question, then who in your firm, your partner who represents Heartland, who is the individual that your partner talks to when he consults with Heartland?
Heartland retained Doug Fulton and Paul Dre within our firm to file a certificate of need.
But my question is, who within Heartland are they communicating with?
Within Heartland, there is Dr. Cherney, and I was going to look at the application. I believe that the responsible person that was listed on the actual application, Your Honor, and I think this was at page 21 of the transcript, is an individual by the name of Nikki Shepard, who is the manager of HPS, according to...
If I could follow up on this Heartland representation, there was some claim by Dr. Cherney, I think, that his personal financial information was given to your law partner in connection with a certificate of need. Was it his personal financial information or the information of Heartland?
Your Honor, the transcript on that, we don't believe, and I don't believe there's any evidence in the record that would indicate that he gave his personal financial information. When we look at the transcript and the questioning regarding what information was received, the information that was received for related to the Heartland Certificate of Need was submitted as part of the application.
And that's Heartland information, and that's information that anybody could go look up. Is that correct?
In order to really put that point home to the lower court, Your Honor, what I did was I went down and I paid $10 and got a certified copy of the record. Anybody that goes down and wants it can get it. I did it myself.
Mr. Mallory, from whose perspective do we determine whether or not there was an engagement? So from the law firm's perspective, their client is Heartland, but I believe Cherney indicates that he believed that the representation also extended to him in his personal capacity. to the extent that he's really the principal behind Heartland. So whose perspective do we look at, and does it matter whether Dr. Cherney had a belief that he may have been represented by your firm?
First of all, Justice, with regards to that assertion, I believe that the record and the affidavit submitted by Dr. Cherney up front, he doesn't even know. He originally doesn't even assert. I think the word that he used was he's unclear as to if he's personally represented or if it was Heartland that was represented.
Let's assume he made a stronger statement, though, just for the purposes of this question.
But beyond that, what we look to when we're dealing with Rule 32 and 113 with the organizational client, the issue is about communication. And if we look at all the comments, we look at what is the communication between the lawyer and the client. The communication in this instance was very clear. The client was Heartland. There was never any miscommunication at all that the representation went beyond Heartland. And importantly, with regards to that, when we ask Dr. Cherney at the lower court about who his attorney was, he was unequivocal. On real estate matters, I use David Wetch. I have always used David Wetch. I have never, in the state of Iowa, I believe it was for over 20 years, he had never used anybody but David Wetch for his real estate entities.
How about if we just go to your partner's retention letter, which refers to Heartland? Wouldn't that be the best way to determine the client?
And that's when I was referring to the communications, Your Honor, between, if there was, when we read the rules and the cases, and I've been doing a lot of reading on, when you have an organizational client, what is the best practices? Because all of us want to abide by the rules. Absolutely, and we believe we have, across the board.
Counsel, I have a question about the record. As I understand it, there was some discussion in July that happened between you and opposing counsel, and then the lawsuit was filed some months later. Then you answered, then there was discussion about discovery, and then the motion to disqualify you was filed. Can you kind of go through a little bit what happened in that period?
Yes, I will. And this really relates to the standard, as to the high standard, as to why these types of motions are disfavored. A client should have the ability to pick their attorney. Now, for strategic reasons, is it possible that someone could make a motion to disqualify counsel? I was involved in this case for 4 to 5 months before anybody ever said anything. Nobody had a problem with it until after the counterclaim was filed. I had been working personally with Mr. Wetch on that. Those emails and evidence of that is in the record. After that time, the petition was filed. They asked me to accept service. I accepted service. After I accepted service, I then answered. After I answered, I then engaged with counsel to negotiate a trial scheduling order and discovery plan. After that is done, I then get notified, hey.
Assuming this is 100% tactical, but we still need to apply the ethical rules to determine under the rules whether there is truly a conflict here, don't we?
I agree, Your Honor. I think that there is no dispute that this is tactical, and that is why the standard is, there is such strict scrutiny. That is why when we look at the rules, we have to first determine who is the client of Brick Gentry. Then, if you, and here's the thing about the identity of the client. The identity of the client is defined as Heartland. I don't believe that there's any evidence to support anything other than that. We have even Mr. Fulton's email confirming that it is Heartland, and he's never represented any other entity. Then to make the jump to Dr. Cherney is not a party to this lawsuit. And so then you have to jump to Dr. Cherney, then you have to jump over to his interest in JSV,
Could you stay close to your microphone so Justice Apple can hear you? Thank you.
I apologize. You then have to jump over to JSV, a wholly unrelated entity which by law cannot be affiliated with this medical entity, and as admitted by Dr. Cherney, has nothing to do with his medical practice, Heartland.
So counsel, 32.1.7A has two parts to it. The first part is when there are clients that are in conflict. The second part, though, talks about a limitation on a representation. Talk about that, if you would. Isn't it possible that there would be some limitation that we should be worried about?
There's never been any assertion below that there would be a limitation in the ability to represent. There's the only assertion that has ever been made from day one is that Dr. Cherney is a client. If we look at their original motion, the court should treat Dr. Cherney as a client. The fault with that analysis is they never make the jump to say Dr. Cherney is the same as JSV, which is then the same as Vivone. You've got to make all of those jumps in order to get the identity. This court and the lower court disregards every corporate formality of multiple entities in order to say all roads lead to Cherney. Under that analysis, frankly, from a practical standpoint, conflict checks would be impossible. You have to look at the entity, all the owners of the entity, all of the entities that those owners own, and then look at the other owners of those entities to determine whether or not they have entities, to determine whether or not you've ever been adverse to them. From a practical standpoint, this is absolutely impossible for an attorney, and that's not how the rules are to be interpreted.
Thank you. I think your time is up.
Thank you.
Mr. Reesner?
May it please the court, counsel. Again, my name is Will Reesner. I'm with the Dickinson Law Firm. I represent Vivone LLC in the underlying matter, but by virtue of the rules of appellate procedure, I'm in effect representing the Iowa District Court for Polk County because this is an action for writ of certiorari. In 1990, this court stated, "We approach our task as a reviewing court in this case conscious of our responsibility to preserve a balance, delicate though it may be, between an individual's right to his own freely chosen counsel and the need to maintain the highest ethical standards of professional responsibility. This balance is essential if the public's trust in the integrity of the bar is to be preserved. Moreover, we are mindful that ethical problems cannot be resolved in a vacuum. This case requires the annulment of Liquor Bike's petition for writ of certiorari, which effectually would be the affirmation of the district court's order disqualifying Attorney Mallory from representation of Liquor Bike and his involvement in the underlying litigation. This court's review of the order disqualifying Mr. Mallory is reviewed for abuse of discretion. This means that the court's factual findings are not disturbed if they are supported by substantial evidence. There is substantial evidence in the record that the court correctly disqualified Attorney Mallory.
I want to ask you a practical question I think that Mr. Mallory closed with. We've all done conflict checks. So how does this work in practice under the district court's rule where she's effectively holding that it's adverse not only to Vivone, but to all of Vivone's owners, and then to all the secondary owners of any entities that may be owners of those companies? How does a law firm run a conflict check under this fact pattern?
Well, Your Honor, ethical problems are not reviewed in a vacuum. We cannot have a bright line rule on how to run conflict checks in order to avoid issues like this. The circumstances of this case are clear that the only person behind all of these entities is Dr. Cherney. So whether or not in certain circumstances there may be other individuals.
Clarify that for me. My understanding is that there is somebody named Roan who's a 49% shareholder of Vivone. Is that correct?
Yes, but completely non-voting has no power over the corporation. It's just an equitable interest.
Meaning is that there are 3 other Cherneys who are also owners of JSV. Is that correct?
JSV is essentially
Is that correct?
It's correct.
There are at least 4 other individuals and another entity that are at issue in this case, not just Dr. Cherney. Is that right?
If it's a yes or no question, that's correct, but I believe that the facts and circumstances matter because we can't review this in a vacuum. We have to look at who's behind those entities and who's making the decisions for those entities.
The comment says, the circumstances are such that the affiliate should also be considered a client of the lawyer. So is your rule such that where the same person is sort of the person with the ultimate decision-making authority in 2 entities, that then a law firm can't represent one entity and be adverse to the other? Is that basically your rule?
I think that when the circumstances are such as in this case, we're the only person making any calls on behalf of the entities, the only person receiving any legal representation on behalf of the entities, the only person who interacts with an attorney on behalf of those entities, the only person that votes. If that's the same individual, I think the circumstances are such that Dr. Cherney should be considered the affiliate for purposes of comment 34.
You would agree with me that in the engagement letter that Brick Gentry provided on the certificate of need matter, the client is Heartland, correct?
I agree that Heartland is identified, but if you look at the letter as a whole, again, we have to look at all the circumstances. The letter is addressed to Dr. Cherney. There's an acknowledgement at the bottom for Dr. Cherney to acknowledge that he's receiving this for Heartland, and Dr. Cherney is the one that signed. Dr. Cherney is the one who spoke with counsel.
You're saying we need to look at all the circumstances. It seems like you kind of want it both ways. You act as though it's a bright line, it's clean, it was violated, and yet it involves a lot of investigation and digging. Isn't that, going back to Justice McDonald's question, which was actually the end of appellant's argument, aren't you kind of placing an almost impossible burden on a conflict check for just any kind of case?
I understand. I agree that it is fact intensive. I agree with that. And that's what our ethical standards require, is to look at the facts. Whether or not it may be difficult for law firms to identify these conflicts, I don't think should overrule the fact that in this case, Dr. Cherney believed that Brick Gentry was his attorney. So the difficulty on law firms should not alleviate law firms of their ethical responsibilities to not represent clients that are adverse to their other clients.
The counsel over here. Sorry. 32.1.7a has 2 parts. The first part is client v. client. But I want you to talk about the second part of it, sub 2. Is there any risk here that there's going to be some limitation by any lawyer in representing any party if Mr. Mallory is permitted to move forward here?
Yes, Your Honor. First of all, I believe that the first prong applies. Liquor Bike is Brick Gentry.
Sorry, so setting aside subsection A1, I want you to talk about 2.
Yep. Mr. Mallory asserted just moments ago that Dr. Cherney did not provide his personal financial information. If you look at appendix pages 70, 71, during the evidentiary hearing on this matter, I specifically asked Dr. Cherney whether he provided more than just Heartland Plastic Surgery's records. Dr. Cherney's answer was yes, he has complete knowledge of my personal affairs. I believe that there is a material limitation on Brick Gentry's ability to represent Liquor Bike in this action when Brick Gentry has full access to Dr. Cherney's personal records.
If it's such a clear connection between the client and this attorney, how come he didn't notice it immediately and blow the horn? I mean, he let a lot of stuff go on. If it's so clear and yet that guy didn't know himself?
Thank you, Your Honor. Mr. Wetch was the primary attorney handling this in our firm. From my review of the emails, he's interacting with Mr. Mallory and then summarizing what Mr. Mallory says and saying that back to the client. There's not a direct exchange of identity of who Mr. Mallory is. And it's in the transcript. The first time that Dr. Cherney became aware that the Brick Gentry firm was involved was when I sent him the counterclaim and said, review these and we'll make our reply here soon. And he saw in the signature block that the Brick Gentry firm is the one on the other side. He did not know that until we sent that counterclaim. So the fact that he and I were discussing the trial scheduling discovery plan does not mean that Dr. Cherney was aware that the Brick Gentry firm was involved.
So was that kind of a conflict check done by you?
I do not recall, and that's certainly not in the record. But I know that when issues like this have come up within our firm, we certainly address it when we come to find out that, you know, the person behind the closely held entity is all of a sudden adverse through a different entity. We certainly address that, Your Honor.
Following up on Justice McDermott's question, can you give me a scenario in which, in the boundary dispute involving Liquor Bike and Vivone, in which Dr. Cherney's personal financial information would be relevant to resolving that case or would limit counsel's representation?
In terms of relevancy under the rules of evidence, I don't believe that it's, you know, strictly relevant, so it's not going to be admitted in court. If we're talking reality here, anytime that there's litigation, this all comes down to money. And opposing counsel's intimate knowledge of my client's personal finances is certainly going to be prejudicial to my client in terms of settlement, in terms of trial strategy, anything. Intimate knowledge of the other side's financials is devastating. So it's not relevant in terms of evidence, but it's certainly relevant in terms of fairness and client confidences, Your Honor.
I see the testimony you're referring to, but it's very vague. I mean, you asked, did you at least provide information, Mr. Fulton, about your financial status? And he answers, of course, he needed everything because, you know, he's the shepherd of this application. So from that, we're to infer that Brick Gentry has financial information that could be valued to them in litigating the boundary dispute. Is that what you're saying?
The answer to the next question, Your Honor, says he has complete knowledge of my personal affairs. So I'd submit that that is more than vague. That is clear that Brick Gentry has complete knowledge of Dr. Cherney's personal affairs.
I mean, that sounds kind of vague to me. I mean, that sounds improbable that that much information would be needed in order to file a certificate of need for a medical clinic. But I have the testimony, so thank you.
You address, I mean, if we back up a little bit to appendix page 65 in the transcript, there's a question, all of that financial information is public information, isn't it? Answer by Dr. Cherney, I wish it wasn't, but I guess it is. So isn't this the same information that's in the exhibit, or if not, please clarify?
It's not, Your Honor. If you look at the first line on that page, it's a question about attachment 8. So this is in reference to an exhibit that was admitted at the evidentiary hearing, and that was the certificate of need application. In the questions that I did on redirect examination, I clarified that there was more information given to Brick Gentry than what was included in the certificate of need application. So Dr. Cherney's response, it is what it is. You can read it, but it was in reference to talking about the exhibit and not all of the other information that's supplied.
Apart from this concern about the tactical advantage of knowing his financial health, or is there any other, can you identify any other concrete harm that would result to Dr. Cherney if Brick Gentry remained as counsel for Liquor Bike?
Frankly, Your Honor, I do not know, but I certainly submit that intimate knowledge of financials is very important. But I think the most important point is no Iowa case law that I have seen requires showing of prejudice or potential harm in order to find that the ethical standards have been violated. The ethical standards are there to promote the public's trust in the bar.
Well, counsel, so if I might, typically, in a conflict situation, there's a concern that a lawyer won't represent a party as fiercely or as vigorously as they otherwise might because they're going soft on the other side because they're a current or former client. And here, if anyone, I think, would have the concern that Mr. Mallory might go soft, it would be Liquor Bike, right? Because they might say, well, you're going to go soft on Mr. Cherney because he's your client on this other deal. Mr. Cherney's concern really wouldn't be the same, right? I mean, on the certificate of need, Brick Gentry would have the same incentive to push hard on that. And so we're not sort of analyzing this maybe in the way that we typically would with a conflict, right?
Well, I agree with you, Your Honor, that is one thing that we ought to look at, but that's not the full picture. The quote that I read to you at the beginning makes clear that what this court is concerned about in looking at ethical standards is the public's trust and confidence in the bar. So we can't just look at it from the perspective of Liquor Bike worrying that Mr. Mallory is going to go soft in the case. We have to look at this from the perspective of Dr. Cherney and the public. Dr. Cherney believed that Brick Gentry was his attorney. He trusted them with information, and now Brick Gentry, while they are still representing him, is now adverse to him.
There are, Mr. Reasoner, there are a lot of cases that indicate what you're arguing, that there's kind of virtual representation of an individual when a law firm is representing a closely held company. So let's assume that's true and that the engagement is with Dr. Cherney and Heartland. What's your best case for kind of the reverse proposition, which seems to me to be more problematic here, in that to find adversity, then you have to pierce through all of these other entities to find that Dr. Cherney is really the truly adverse party. So, I mean, that's kind of where I'm struggling with it, is even under the best case, and you assume Dr. Cherney thought that Fulton represented him personally, how do you get to adversity when there are multiple layers, and what's your best case that stands for that proposition?
Your Honor, my time is up. May I respond to the question? Thank you. In terms of the best case, the best legal case that I've seen so far is Connecticut Limousine versus Industrial Roofing and Paving. It's a Superior Court of Connecticut case, so a district court case essentially. And that is cited in the briefs. The facts of that case are nearly identical here. And what the court did was look at the circumstances. The fact that, I wouldn't even call these hurdles that you have to look at JSV to get to Vivone, to get to Dr. Cherney, because the circumstances are such that Dr. Cherney is the only person with any vote for any of these entities. He's the only person with any of these entities that seeks legal representation. He's the only one that speaks to an attorney. So these appear to me to be artificial hurdles. We're not talking about piercing a company for liability in order to collect a judgment. We're talking about client confidences in attorneys and who holds that confidence. I submit that in closely held corporations and entities such as what we have here, the client confidences are held by the individual who's behind all of these entities. And any bright line rule that would seek to, discredit these client confidences on the basis of a legally created entity is not what our ethical standards and the principles underlying our profession have stood for up to this point, Your Honor.
Thank you. Mr. Mallory, you may respond.
A couple of things. First of all, with regards to...
Counsel, you need to engage the mic, please.
Sorry, Justice. First of all, with regards to the assertion that in the entity of Vivone, there's no other individuals who act on behalf of that. If we look at the transcript from Mr. Cherney's divorce, which was introduced into evidence, Ms. Rowe's husband is the one who does all the day-to-day operations there. If we look at the articles for the operation of the entity, I don't believe that shows that she has a non-voting stake in that entity. I believe that the non-voting stake that was referred to is with regard to the 3 children in JSV. However, this court has held that, just because you have a non-voting stock ownership interest, you still, the only thing you don't have a right to do is vote. You still have all rights and entitlements of membership. Second, with regards to
Counsel, sorry, I have a question about the factual situation here. What evidence do you have that Mr. Cherney knew that your firm was representing Liquor Bike prior to the time that Mr. Reasoner says?
I know that since the year of 2003, my
Sorry,
name,
I'm talking about record evidence in this record that Mr. Cherney knew that your firm was involved.
we have not sought to invade the attorney-client privilege between Mr. Reasoner and his office and Mr. Cherney. I can state that of public record, since 2003, I have been listed as the registered agent for Liquor Bike LLC. That predates even Vavone's acquisition of this property in 2013. I know that Mr. Wetch has practiced a long time. I know that he is well aware of his obligations to keep his clients informed of what is going on in a case, and he certainly knew I was involved in this matter that we were dealing with.
Next record question. The certificate of need matter, that was still ongoing at the time that the district court was ruling on its motion here?
Yes.
We're talking about a current client and not a former client? In terms of Heartland?
Heartland was a client, yes. Now, that gets to a question or issue raised by Justice McDonald about, we do a lot of talk here about, is Cherney Heartland? Is Cherney our client? But then we don't want to lose sight of the fact that Cherney's not a party to this case. JSV is not a party to this case. The party to this case is Vavone, and Dr. Cherney stated on the record at page 33 that that is not affiliated with Heartland. So there is no affiliation between these entities. Now, the idea, the testimony about the personal finances and personal affairs, I think that is vague at best. Even at one point in time, I had asked a question about, do you recall, or actually, this was Mr. Reasoner asking, did you have any questions with Doug Fulton about your financial status? I think that starts out, I don't recall, but probably. So at best, we're very vague as to what was provided. We do know that it was filed. Now, the lower court really relied on comment 6 and says, which in that ruling, the judge looks to comment 6 and takes an excerpt. If we look at the entire comment and look to the last sentence, that is pivotal. First, I believe that it's the comment 34 and the organization is the client. That's controlling, as that's what I would respectfully submit. But if you look at comment 6, it says that simultaneous representation in unrelated matters of clients whose interests are only economically adverse, such as representation of competing economic enterprises in unrelated litigation, does not ordinarily constitute a conflict of interest. And what we have here is we have an individual who has an ownership interest in a number of entities, admittedly unaffiliated entities. And because these are unaffiliated entities, because the organization is the client, because we have consistently held that corporations are separate and distinct from their owners, when applying the rules as written, this court should reverse the decision of the lower court and allow myself and my firm to stay involved in this case.
Counsel, is Dr. Cherney a key witness in the boundary dispute?
No, and we do hit on that in the transcript. The fact of the matter is my client acquired the contract interest in this property in 2004. I was involved in that transaction. 2008, the deed was acquired by my client. Dr. Cherney, as evidenced in the transcript of his divorce proceeding, his interest in the property arose in 2014 well after all of it. And he had no knowledge of this property prior to that date. So, and the issues involved in the boundary dispute all predate his ownership. He has no personal knowledge of any of this.
Thank you. The case of Lickerback versus Iowa District Court for Polk County is hereby submitted. We are going to take about a 5-minute recess from the bench, and we will return and start with Barkalow versus Clark.